A Supreme Court decision just dropped that could send you to federal prison if you misunderstand it, and right now, the internet is spreading the wrong information at lightning speed. The headline you're seeing everywhere says the Supreme Court just changed both First and Second Amendment rights in an 8-1 decision, and that's partly true. But the way people are interpreting it is dangerously wrong. This isn't about political spin. This isn't about taking sides. This is about the difference between understanding your rights and losing them because you believed a viral post instead of reading what the court actually said. If you own a gun, if you're going through a breakup, if you've ever had any kind of restraining order situation in your life, what I'm about to explain could be the difference between walking free and facing federal charges that destroy everything you've built. Before we go any further, hit that subscribe button right now because the information I'm about to give you could literally save you from a decade in prison. This isn't hyperbole. This isn't clickbait. This is about federal law that applies whether you know about it or not, and ignorance has never been a defense. Like this video, drop a comment telling me if you've heard the wrong take on this case, and share this with every gun owner you know because the misinformation is spreading faster than the truth, and people are making decisions based on bad information that will come back to haunt them. Here's what actually happened, and I need you to understand this clearly because the details matter more than the headline. The case is called United States v. Rahimi, and it was decided 8-1 by the Supreme Court in 2024. The question before the court was simple and specific. Can the federal government temporarily prohibit someone from possessing firearms if that person is under a domestic violence restraining order, and a court has found that person poses a credible threat to someone's physical safety? The Supreme Court said yes. That's the holding. That's what the decision actually says. If a judge has determined through proper legal process that you are a credible threat to another person's safety, the government can disarm you temporarily while that protective order remains in effect, and that does not violate your Second Amendment rights. Now, pay attention to what the court did not say, because this is where the confusion starts and where people are getting themselves into serious trouble. The court did not say the Second Amendment is weakened or diminished. The court did not say anyone who gets accused of anything automatically loses their gun rights. The court did not say states can disarm people just because officials feel like it or because someone filed paperwork. This decision is about a very specific type of court order with very specific legal requirements and a very specific judicial finding: a credible threat to physical safety. That specificity is everything. And if you don't understand those distinctions, you're going to believe the panic narratives spreading online that claim this decision opened the door to mass disarmament based on accusations alone. That's not what happened. That's not what the law says. And believing that myth could make you complacent about situations where you actually are at legal risk. Here's why this case matters beyond just the immediate holding about restraining orders. This decision also addresses how courts should apply the Bruen framework going forward. And if you follow gun law even casually, you know Bruen changed everything when it came down in 2022. Bruen told courts they had to judge gun laws by looking at historical tradition, not by doing modern balancing tests, where judges weigh rights against public safety concerns like they're ingredients in a recipe. After Bruen came down, lower courts went absolutely wild trying to figure out what history and tradition actually means in practice. Some judges started demanding that the government produce a nearly identical law from 1791 to justify any modern gun regulation, basically requiring a historical twin, an exact match from the founding era. Other judges took a broader view and allowed comparisons based on principle rather than demanding perfect replicas. The chaos was real, and it was affecting real cases with real consequences for real people. The Supreme Court in Rahimi basically said, stop playing games with the history requirement. They explicitly stated that the Second Amendment is not a law trapped in amber. In plain English, that means the Constitution isn't frozen like a fossil in rock, preserved exactly as it was in 1791 with no room for application to modern circumstances. You don't need a perfect historical twin from the founding era. What you need is a historical analog. something close enough in the important ways, in the principles that matter. The court explained that the key inquiry is the why and the how. Why does this law exist? What specific problem is it trying to prevent? And how does it burden the right? How broad is it? How long does it last? How much does it restrict? Those questions become the new battleground for every gun case going forward. Even though Rahimi is specifically about domestic violence restraining orders, it sends a clear signal to every lower court in America about how to handle gun cases under the Bruen framework. You're not allowed to demand an exact statute from 1791. You must look for comparable principles, analogous reasoning, similar regulatory purposes. That shift is massive because it can cut both ways. It can save some gun regulations by allowing broader historical comparisons, but it can also destroy other regulations by forcing courts to honestly examine whether the historical principle actually matches or whether the government is just making stuff up. That's huge for future litigation, and it's why this case matters even if you never plan to be anywhere near a restraining order. Now let me make this concrete with a story because abstract legal principles don't stick in your memory, but stories do. Imagine a guy named Mike. Mike isn't a felon, he's not a gang member, he owns guns legally, carries legally, goes to the range every weekend. He's just going through a nasty breakup with his girlfriend. Things get heated. She files for a protective order. Mike thinks this is just family court drama, just paperwork, just temporary relationship stuff that'll blow over once emotions calm down. That assumption is the mistake that ruins his life. Because if that protective order checks certain legal boxes, and especially if it includes specific judicial findings about credible threats or danger, Mike can suddenly find himself in federal felony territory just for possessing a firearm while the order is active. He didn't commit a new crime, he didn't threaten anyone, he just kept his guns at home like always. But under 18 U.S.C. 922 G8, that's enough to send him to federal prison. This is why you cannot treat restraining orders like they're just drama or inconvenience or relationship noise. Temporary can still mean handcuffs. Temporary can still mean federal charges. Temporary can still mean you lose your rights permanently even after the order expires, because now you have a federal conviction on your record. The legal system doesn't care about your intentions or your side of the story or whether you think the order was justified. The system cares about what's written in the court order, what findings the judge made, and what you did next. The question everyone asks at this point is obvious. How can the court uphold this kind of restriction and still say we have a right to keep and bear arms? Here's the straightforward answer that courts have been giving for years. Even in the biggest pro-gun decisions like Heller and McDonald, the Supreme Court has repeatedly said that the Second Amendment right is not unlimited. Not unlimited doesn't mean weak or meaningless. It means there have always been some regulations, some boundaries, some circumstances where rights can be restricted based on specific findings and proper process. The Rahimi majority explained that historically, American law has always had mechanisms to temporarily disarm people who pose genuine threats of violence. They pointed to older laws designed to prevent violence and punish people who terrorized others with weapons. In plain English, the court said that if you're a proven threat through proper judicial process, society has always had tools to deal with you, and temporarily removing your access to weapons fits within that historical tradition. Here's the part that shocked a lot of people who follow the court closely. Rahimi was 8-1, not a narrow 5-4 split, not a partisan battle. 8 justices agreed with the majority opinion. Only Justice Thomas dissented alone. If you were expecting this to break down along predictable ideological lines, this case didn't do that. The broad consensus suggests the court sees this issue differently than the typical gun rights debate, probably because it involves specific judicial findings about threats rather than broad categorical bans. There's another crucial detail most people are missing in all the noise. Rahimi brought what's called a facial challenge to the law. In normal language, that means he wasn't arguing that the law was unconstitutional as applied to him specifically. He was arguing that the law is always unconstitutional under any circumstances for anyone. That's the hardest kind of challenge to win because to succeed, he had to prove the law could never be valid, not even in a single case. The court said we don't have to decide every imaginable scenario. The law is clearly valid in situations like yours, where a court found you were a credible threat to someone's safety, so you lose. When the court decides a case that narrowly, it matters because it keeps the precedent more limited than people think. This isn't the court saying we approve every possible application of this law forever. This is the court saying the law is constitutional, at least in the kind of situation we're reviewing here, where proper process was followed and specific findings were made. If you're still watching, drop a comment and tell me whether you think this decision helps or hurts gun rights overall, because the answer isn't as simple as the partisan talking points suggest. And make sure you're subscribed because I'm going to break down exactly what this means for future cases and what you need to do to protect yourself. Now let's talk about the First Amendment angle, because this is where the headline about both amendments gets interesting, and it's also where a lot of confusion comes in. The First Amendment piece isn't part of the Rahimi decision itself. Rahimi is purely a Second Amendment case about restraining orders and gun possession. The First Amendment component comes from different Supreme Court battles that hit the gun world in a completely different way, but the connection matters and you need to understand it. Here's the First Amendment issue in simple terms. The government cannot use its regulatory power to secretly pressure private companies into punishing speech that the government doesn't like but can't directly ban. That includes gun-related speech, that includes gun advocacy organizations, that includes firearms businesses and instructors and content creators who talk about weapons. Why does this matter to gun owners who think they only care about the Second Amendment? Because in the real world, the fastest way to destroy a movement or silence a group isn't always to pass a law banning them. Sometimes it's easier to cut off their banking, their insurance, their payment processing, their basic business services. And if government officials can quietly suggest to heavily regulated financial companies that they should stop doing business with certain speakers or certain industries while waiving the implicit threat of investigations or enforcement actions, that becomes a backdoor method of censoring speech without ever passing a censorship law. That's a First Amendment problem, and gun owners should care deeply because the gun debate isn't only about whether you can own firearms. It's also about whether you can talk about firearms, organize around firearms, teach about firearms, advocate about firearms, and build businesses around firearms without being systematically deplatformed. Most gun owners make a critical mistake. They think the Second Amendment is all that matters. But the First Amendment is the engine that lets you defend the Second. If you can't speak freely about guns, you can't rally public support for gun rights. If you can't organize, you can't fund the lawsuits that protect gun rights. If you can't advocate, you can't push back against politicians trying to restrict gun rights. The amendments work together, and attacking one is often a strategy for undermining the other. So when you hear headlines claiming both amendments changed, the accurate way to understand it is this. The Supreme Court clarified how courts should evaluate certain gun restrictions under the Second Amendment using historical analogs rather than demanding impossible historical matches. And separately, courts have been reinforcing limits on government pressure campaigns that threaten free speech under the First Amendment. Two different legal lanes, but they collide in the real world where gun owners live and work. Here are 5 big takeaways that actually matter to your life. And I'm going to give these to you straight because this is where knowledge becomes power or ignorance becomes prison time. First takeaway. Credible threat is not just a phrase thrown around in court documents. It's a legal trigger with federal consequences. In Rahimi, the court specifically cared that a judge had found through proper legal process that the defendant posed a credible threat to another person's physical safety. So, if you ever find yourself dealing with a protective order situation, you need to understand exactly what that order says. Does it contain language about credible threats? Does it include specific findings about violence or danger? Does it explicitly reference threats of physical harm? Those details can determine whether simple gun possession becomes a federal felony while the order is in effect. Second takeaway: notice and the opportunity to be heard actually matter in the legal system. A major reason the law in Rahimi survived constitutional scrutiny is because it involves court procedures that are supposed to give notice and a chance to respond before the restriction takes effect. That doesn't mean the system is perfect or that you're automatically safe if you show up. It means you absolutely must take these proceedings seriously and participate in them, because ignoring a protective order hearing can become the very thing that makes your legal situation catastrophically worse. The system gives you a chance to contest the findings. If you don't take that chance, you have no one to blame when the consequences hit. Third takeaway: temporary doesn't mean harmless or consequence-free. People hear temporary disarmament and think it's no big deal, just a minor inconvenience that'll pass. But if you get charged with violating the prohibition, you're not dealing with temporary stress. You're dealing with permanent destruction. Federal charges mean federal sentencing guidelines, legal fees in the tens of thousands of dollars, a criminal record that follows you forever, restrictions on employment, housing, voting rights. Even if you eventually win your case, the process itself becomes the punishment. That's why you cannot afford to gamble with this stuff or assume it'll work itself out. Fourth takeaway: Bruen is still the controlling test for Second Amendment cases, but Rahimi tells courts how to apply Bruen correctly going forward. This decision doesn't erase Bruen or replace Bruen. It instructs lower courts on how to use the Bruen framework without playing absurd games that demand perfect historical matches from 1791. And that matters tremendously for future gun litigation, because now judges can't just say, "I didn't find an identical law from the founding era, so this modern regulation automatically fails." They have to ask whether the modern law matches a historical principle in the ways that actually matter: the regulatory purpose, the scope, the burden on rights. That standard can save some regulations and destroy others. But the key point is the Supreme Court is telling lower courts to stop manipulating history to reach predetermined outcomes. Fifth takeaway: the First Amendment matters far more than most gun owners realize, and if you ignore it, you do so at your own peril. If you run a gun shop, teach firearms classes, create content about weapons, or support Second Amendment organizations, you are potentially affected by the speech side of this legal landscape, because pressure and censorship can come through channels you don't expect. Banks can close your accounts, insurance companies can drop your coverage, payment processors can freeze your funds, social media platforms can delete your content. And the legal fight over whether the government can push those private companies to target lawful speakers is a major part of the constitutional landscape right now. Understanding that connection makes you smarter and more prepared than 99% of gun owners out there. Here's a truth that makes people uncomfortable, but I'm going to say it because you need to hear it. A lot of gun owners lose their rights without ever committing what they think of as a gun crime. They lose rights because of paperwork, because they ignored a court hearing, because they didn't read the terms of a protective order, because they assumed civil court means not serious, because they got bad legal advice from the loudest guy on the internet who doesn't know what he's talking about. Don't be that person. Don't let ego or ignorance cost you everything. If you're finding this information valuable and you want to stay ahead of these issues instead of learning them the hard way in a courtroom, subscribe right now. Comment below and tell me what questions you still have about this case. Share this with every gun owner, instructor, and Second Amendment supporter you know, because the misinformation is spreading faster than the truth, and people are making life-altering decisions based on bad information. Let me walk you through 3 scenarios so you can see how this plays out in real life. Because abstract legal theory doesn't help you when you're sitting in the back of a police car trying to figure out what went wrong. Scenario 1. You're driving home from the range. You've got a firearm locked in a case in your trunk. Everything's legal. You're obeying all the rules. An officer pulls you over for speeding. Now you're nervous. You start over-explaining. You start reaching for documents without being asked. You start talking fast, word-vomiting information the officer didn't request. Here's why this connects to everything we've been talking about. Your words in that moment are your First Amendment in action, and your firearm in the trunk is your Second Amendment reality. The worst thing you can do is panic and create suspicion where none existed. I'm not telling you to be confrontational. I'm not telling you to refuse to cooperate. I'm telling you that understanding your rights means acting smart, staying calm, and not volunteering information that can only hurt you. Scenario 2. You're going through a messy breakup. Things are tense. Emotions are running high. One night in anger, you send a text message that's harsh and hostile. In your mind, it's just venting frustration. It's not a threat. You're just angry. But the next day, you get served with paperwork for a protective order hearing. Here's the mistake almost everyone makes in this situation. They think this is emotional. This is personal. The judge will see through it and understand my side. But the court isn't reading your mind or judging your character. The court is reading what's on paper, the petition, the alleged facts, any evidence of threatening behavior. And if an order gets entered that includes judicial findings about credible threats or danger to safety, it can change your gun possession status from legal to federal felony overnight. The smart move is simple but critical. Take it seriously from day one. Get legal counsel immediately. Understand what the petition alleges and what the order might say. Do not violate any terms of the order. Do not send just one more message to explain yourself. Do not show up at her house just to talk. The system doesn't care how you meant it. The system cares what you actually did. Scenario 3. You run a small gun-related business. Maybe you sell firearm accessories. Maybe you do training and instruction. Maybe you manufacture holsters or teach safety classes. You're not doing anything illegal. Everything is licensed and legitimate. But one day, your payment processor drops you without warning. Then your bank starts asking strange questions about your business activities. Then your insurance broker informs you that your policy won't be renewed. You ask why, and nobody gives you a straight answer. Just vague references to risk assessment and business decisions. This scenario should terrify every person watching because even without passing a single new gun law, a coordinated pressure campaign can make lawful businesses and lawful speech economically impossible to sustain. And that's exactly why the First Amendment side of this story matters just as much as the Second Amendment side. The right to keep and bear arms means nothing if you can be economically strangled for exercising it or talking about it. Now let's address the biggest myths I've seen flooding the comments and spreading across social media because bad information is actively harming people. Myth number 1. So this means if someone accuses you of something, you automatically lose your guns. No, that's not what Rahimi says. Accusation alone is not the standard. The decision talks about a court finding tied to a credible threat determination, and the law requires procedural protections, notice, hearing, opportunity to contest. That doesn't mean the system can't be abused or that false accusations never happen. It means the court's reasoning is grounded in judicial process and specific findings, not mere rumors or allegations. Myth number 2. The Supreme Court just said the government can disarm anyone it labels dangerous. No. In fact, the court explicitly rejected vague, open-ended standards. They did not create a blank check where the government can slap a dangerous label on you and take your rights with no due process. They focused specifically on credible threat findings made by courts through proper procedure, and they tied it to a historical tradition of dealing with proven threats of violence. If you care about due process, and you should, then you should understand that distinction because it's what prevents this from becoming arbitrary government power. Here's something that might annoy people, but it's the truth, and you need to hear it. If you are a gun owner, you have to be the most careful, most boring, most by-the-book person in the room when conflict starts. Not because you're weak, not because you're scared, because you have more to lose. The legal system is not forgiving when firearms are involved. A mistake involving a gun is treated as a far more serious mistake than identical behavior without a gun. That's just reality. That's the world we live in. And if you don't like it, your options are to change the law through political action or to be so careful that you never give the system an excuse to come after you. Now here's what this means for the future of gun law litigation, because Rahimi is going to be cited in virtually every major Second Amendment case going forward for one specific reason: the historical analog language. Courts have been all over the map since Bruen came down. Some have struck down gun laws quickly. Others have upheld laws quickly. Some have demanded extremely specific historical examples from the founding era. Others have allowed much broader historical comparisons. The chaos has been real, and it's created unpredictability in the law. Rahimi signals that the Supreme Court is watching that chaos and telling lower courts to stop demanding impossible historical precision. Use analogy, use principle. Look at why the law exists and how burdensome it is, not whether you can find a perfect match from 1791. That clarification can cut both ways. It can help the government defend certain gun regulations by allowing broader historical comparisons, but it can also help gun rights plaintiffs because it forces courts to be honest about the history they're citing. No more cherry-picking isolated examples. No more pretending rights only existed for perfect people in perfect circumstances. No more inventing standards out of thin air to reach preferred outcomes. Courts have to focus on the regulatory purpose and the burden on rights, which creates a more honest framework for evaluating laws. Let me give you a hypothetical to show how this plays out. Imagine a state passes a law saying anyone who has ever been treated for depression cannot own a firearm, period. Most people would instinctively recognize that's too broad, too sweeping, too disconnected from any individualized finding of actual danger. Under the kind of reasoning discussed in Rahimi, a court would have to ask, is this law aimed at addressing a specific proven threat based on individual circumstances, or is it just a broad categorical ban based on a label? Is there an individual determination of dangerousness, or is it automatic? Is it temporary or permanent? What process does the person get to challenge it? How heavy is the burden on the right? Those questions become the battleground for future litigation, and they force courts to think more carefully about whether regulations are actually analogous to historical practice or just modern preferences dressed up in historical language. If you only remember one thing from everything I've said, remember this: most people don't lose their rights in dramatic moments. They don't lose rights in shootouts or standoffs or confrontations with police. They lose rights in boring moments, a court date they skipped because they thought it wasn't important, a form they didn't bother to read carefully, a message they sent in anger without thinking through consequences, a restraining order they assumed was just temporary drama. And the law does not care that you're normally a good person who made one mistake. The law cares about what's documented, what's filed, what's ordered, and what you did in response.